very good evening to each and everyone present here. It gives me an immense privilege to welcome each and every one of you, especially our esteemed speaker, Shri Atul Damale sir, our dignitaries, great lawyers from our court, as well as all the law students. But before we proceed, we all know that the topic for today's lecture is testamentary succession and wills. In fact, everyone's involvement here shows that today we have the best speaker for today's topic. But before we proceed, may I please request Julie Gadge to let us know, to introduce our organizers, Adhivakta Parishad and Advocates Association of Western India.
Thank you, Mayor. Good evening and warm welcome to all. So let me give brief introduction about Akhil Bharatiya Adhivakta Parishad, Advocates Association of Western India and our V.T. Valavalkar lecture series. Adhivakta Parishad was founded in the year 1992 with the initiative of nationalist thinker and social reformer Shri Dattopanta Thengdiji. Adhivakta Parishad is founded with the object of resurrecting Bharatiya values and ingraining idealism in the hearts of advocates for improving efficacy and standards of the bar and the judiciary of the country. The motto of the organization is Nyaya Mama Dharmaha. Adhivakta Parishad is all India organization which is working for national resistance. We believe that lawyers should have larger vision. He is a social engineer. Lawyer is the best defense of the social order and justice. In light of this belief, Adhivakta Parishad supplements and complements efforts made by field organizations and selfless persons working at the grassroots levels. Adhivakta Parishad tries to develop rapport with the various organizations, NGOs, communities, individuals who work for the society and who are socially active. We believe that advocates will have to work along with the other organizations to usher in this new era. The advocates who have inner urge to discharge their duty towards the society are to be organized and their efforts are to be streamlined. There is a need to evolve robust organizational structure networking of the lawyers. Today's lecture series is one such effort. This V.T. Valavalkar lecture series is our flagship lecture series which we started in the year December 2017, and today more than 25 lectures are conducted in this lecture series. We were fortunate to have sitting chief justices, retired judges, senior counsels as our speakers. Also, we were fortunate to conduct we covered various topics like NCLT, RERA, cyber cases, service law, consumer law, domestic violence, art of cross-examination, crossing of FIR, so on and so forth. And we aim to continue this lecture series covering various range of the topics. Now, smallly introduction, the Advocates Association of Western India did not require any introduction, but still as my duty, I would briefly introduce the Advocates Association of Western India. It is the oldest bar association in India, established in the year 1864. It continues to provide critical linkage between population of the remote areas and the judiciary. The association restored nation with prominent leaders who played vital role in the struggle to achieve independence. The association since its inception has persevered to meet the dynamic needs of the legal fraternity and pave the way for the judicial reforms. The motto of the association is respect the law and the law protects you. The association has produced many illustrious legal personalities who provide a source of inspiration to the present generation of lawyers with their undaunted courage and tenacity. I thank the association to coordinate with us for this lecture series. Over to you, Mayor. Thank you.
Thank you, Julie. Now may I please request my friend. Thank you, Julie. Now may I please request my friend Shri Katneshwarkar to introduce our esteemed speaker, Shri Atul Damale sir.
Thank you, Mayor. Shri Atul Gajanan Damale has been practicing since past 32 years in the Honorable Bombay High Court and has been appointed as Senior Counsel in the Honorable Bombay High Court in the year 2014. He has a vast experience in field of law. He appears on both the sides, original and appellant, in civil as well as criminal matters. He has appeared for various corporations, banks and state. Thereby I request Shri Damale to kindly take the stage and enlighten us upon the today's topic.
you, Shri. May I please request Abhay Khandeparkar sir to kindly felicitate our esteemed speaker, Shri Atul Damale sir. Thank you, sir.
Can I?
Yes, I hand over mic to us.
Thank you. I think I have made one short note which will be circulated to everybody on the topic which we have. Today we have a topic of the law of succession in India, where there is the succession is in two parts. One is a testamentary succession and one is interstate succession. Interstate succession, where there is no writing or a will or a wish of a deceased. In that case, an interstate succession will come in. When there is a will or any writing by which a deceased has given his intentions of disposing of his property, then it will be called as a testamentary succession. We are going to, I am going to address you on that topic of a testamentary succession. And testamentary succession is basically which is known as a will, where a deceased or a person makes a will by which he records his wish of disposing of his property after his death to whichever person, either his legal heirs or even a third person, he can do that. So, in the provisions of Indian Succession Act will be the important provisions on the discussion of this topic. For that, there are in Indian Succession Act various definitions have been given, such as in a section 2, the definition of a will is given. Will means is a legal declaration of intention of a testator with respect to his property, which he desires to be carried into effect after his death. So any writing which has been made by a person will come into effect, or effect is given after the death. Then in that there is one more definition. I am giving the definitions of the sections which are important for the purpose of understanding the whole the system of granting a probate, letters of administration, and how the testamentary succession works. Then one more definition which is important is of codicil. Codicil is known as an instrument in relation to a will and explaining, altering or adding its disposition. So after a person making a will, if he feels that it has to be amended or added, or some disposition which has been done has to be removed, that can be done, and the same is called as a codicil. Then there are two more definitions are mentioned over here. One is the administrator. Administrator is a person who can be appointed as an administrator after the death of a person who has executed a will, and who is the person who is going to administer the estate of the deceased as per his wishes, which has been mentioned in the will. That administration cannot be done. I'll come at a later stage. That administrator will come into effect, or his powers will come into effect only when the court accepts him as an administrator. Then one more definition will be required is of an executor. When executor is the person to whom the execution of the last will of a deceased person is by testator's appointment confided. The executor is a person who should be named in the will. If a will mentions somebody as an executor, then only the person can act as an executor, and then only the person can go and file application for probate and can administer the estate as per the wishes of the testator. So these are the important definitions, and even a probate has been defined under the Indian Succession Act. Means the copy of a will certified under the seal of a court of a competent jurisdiction with the grant of administration to the estate of the testator. So these are some of the important definitions which are required to be looked into when we look into the testamentary succession. Then the testamentary succession is mentioned in part 6 of the Indian Succession Act. Part 6 is divided into 6 chapters. We will go one by one in that. The first chapter is the section which starts with section 57, which is application of certain provisions of this part to class of a will made by the Hindus. So these provisions will be made applicable to the Hindu, Jain and other except the Muslims, because for Muslim there is a different personal law under which their wills and other testamentary documents are to be acted upon. Then section 59 is the most important section, a person capable of making a will. The capacity of a person is something like what we know as a person capable of entering into a contract, that the person must be of a sound mind, a person must be major. He must be, and in addition to that, in case of a will, the person must be having a disposing mind. His mind should be stable. He must be in a position to understand what the disposition is making in that will. The section 59 is the person who is which describes the person who can make the will. So as we know under a contract, the similar requirements are there. One is he should be major. He should be a person of a sound mind, and he should be in a position to understand what he is disposing of or what his wishes which he is incorporating in. Then the second section, which is more important, is section 61, which is wills obtained by fraud, coercion and undue influence. So these type of wills are stated to be void. It's similar to the Contract Act, where a contract is executed if it is executed by fraud, force or coercion. It's similar for the purpose of will also. In such cases, the will become void. Then section 63 is in respect of the unprivileged will. Unprivileged will is the normal will which we look into it, because privileged will can be executed by only a soldier who is who is not in position to execute his will according to the section 63. So normal will, which section 63 describes, is the unprivileged will, and section 63 gives so many requirements for a unprivileged will to be properly executed, because ultimately if section 63 is followed, then only that will can be treated as a legal and valid will, which can be put before the court for obtaining a letters of administration of a probate. So I'll just read the requirements which has been mentioned under 63. Every testator not being a soldier, employed in an expedition or engaged in actual warfare, or an airman so employed or engaged, or mariner at sea shall execute his will. So mariner soldiers are excluded. So their wills are called privileged will, and the rest are called as unprivileged will. And the requirements are as follows: the testator shall sign or shall affix his mark to the will, or it shall be signed by some other person in his presence and by his by his directions. So two things are required. A person can put a signature, as well as there is one more addition is done, is that he can even put a mark of his approval to the will. Or if he is not in position to sign for some reason, then at his instance or at his discretion, somebody else also can put his mark for approval. Then signature, the second requirement is signature or mark of a testator or a signature of a person signing for him shall be so placed that it shall appear that it was intended thereby to give effect to the writing as a will. So there should not be any confusion while execution. There has to be a proper marking, signature, accepting the contents which has been mentioned in the said will. And the third requirement is will shall be attested. This is more important. The will shall be attested by two or more witnesses, each of whom shall seen the executor sign or affix his mark to the will, or has been some other person sign the will in presence of and by direction of a testator, or has received from the testator a personal knowledge of his signature or mark, of the signature of such other person, and each of the witnesses shall sign the will in the presence of the testator, but it shall not be necessary that more than one witness be present at the same time, and no particular format of attestations shall be necessary. So this is the more important condition which has been prescribed under section 63, is that there must be two or more attesting witnesses at the time of execution of a will. There are various judgments which says that the testator, the witnesses must be present at the same time at the time of putting their signatures. And even any one of a witness was present, and there are requirements of ideally both witnesses should be present when the testator put his mark or a signature or a thumb impression on the will, as well as the witnesses also put their signatures. But that condition has been little modified in the same clause C itself, that even one witness is present, and if he can put his signature, still that will can be treated as a legal and valid will, and the other witness can subsequently sign. Then the other more important this thing is section 74, which gives what should be the wordings of the will. The section says that there is no fixed wording or there is no format or anything. It should be only clear intention of the testator should be reflected in the will. That whatever his intention, whatever his bequest he wants to make it, there should be clarity. That's the only thing which is said in section 73. There is nothing else which has been prescribed. No format for will has been prescribed anywhere. Then the chapter 7 is of a void bequest, because since we are dealing with this part, we have to see what bequests can be legal. The three sections have been mentioned that about the void bequest is, the first is section 112, where bequest to the person by a particular description who is not in existence at the testator's death. So if a person who is not in existence at the testator's death cannot be bequeathed with the property by the testator. So the requirement is that if a bequest is done, or if a will is executed by a person, then a bequest is to be made to the person who is living person. It cannot be given to somebody who is in future going to come, or in that sense who is not in existence. And even if such bequest is done, it is treated as a void bequest, illegal bequest. Then section 113 is the bequest to person not in existence at a testator's death, subject to prior bequest. So if there is a prior bequest and there is a further bequest, and even that person is not in existence, even that is held to be a invalid this thing. And section 114 is against the rule of perpetuity. By will, you cannot give a property in perpetual succession. You can give it to only one person, and then once a property is given to one person, after the probate or letters of administration is granted, it is his wish, because it becomes his individual property, and therefore there cannot be any perpetuity in succession. Then we have the part 8, which is in respect of a representative title of the property of a deceased on succession. Part 8 is in 3 sections. Section 211 and 213 are the 2 sections, which says that once a letters of administration or any will is declared to be void, valid will, or if even before the will is certified by any court of law, the person who is named as an executor will represent the estate of the deceased, because the effect of a will always come in when after the death of a person who executes the will. So the issue will be who will administer the estate of a deceased after his demise. After his demise, till the letters of administration of a probate is granted. But once the probate or letters of administration is granted, of course the person who is named as an executor or a beneficiary accepted by the court will represent the estate of the court. But there are some judgment which says that even till the time the actual certification in the form of a probate or a letters of administration is done, till that time also the person entitled to represent the estate of the deceased is the executor named in the will, or administrator named in the will, or any beneficiary who can represent the estate of the deceased. Then for us there is one more important section is 213(2), which is by way of an amendment, which says in fact 213(2) Roman 2, because which says that these proceedings of probate are required to be filed only in the places that is the chartered high courts which were there earlier, that is Bombay, Madras and Calcutta. So this distinction is made so far as the Bombay jurisdiction is concerned in respect of the will or the probates, and for the rest of the part of the state. For Bombay, because of section 213(2) Roman 2, the requirement is that if a will is executed by a person is within the city of Bombay, or if he is a resident of Bombay and left the properties in Bombay, then without obtaining probate, his properties cannot be passed on to the person who is claiming under them. So probate is must. If there is no executor mentioned, then a letters of administration can be filed by a person who is within the city of Bombay. But that mandate is not there for the persons or the wills which has been executed on the properties which are outside the jurisdiction of original jurisdiction of a Bombay. In such cases, it is not mandated that a person must take the will and go to the civil court for obtaining a probate. It is his discretion, he can do it, but for the city of Bombay, it is a mandatory. In outside the city of Bombay, a person can go to the civil court for establishing his right under the will either he can apply for as an executor, or if there is no executor, then he can apply as for the letters of administration to administer the estate. Then the part 9 is in respect of probate letters of administration and administration of assets of the deceased. As I have already said, chapter 1 of part 9 is since it starts from section 217 and 218 and 200 till 222, 22, 27. 218 is who can be appointed as an administrator, which has been described. So any person can be appointed as an administrator, who is, of course, these provisions are not applicable to the Muslims, but it is applicable to all others, Hindu, Jains, Sikhs, and other persons. Any person who, even if he is a beneficiary, can be appointed as an executor by the court. So that is contemplated under section 218. Then 222 makes that distinction which I have said, that if an executor is named, then only a probate petition can be filed. If there is no executor which has been mentioned in will, then a person who wants to go and get approval of a will has to file a letters of administration along with will, which is termed as a letters of administration with annex will. And that distinction has been made because of section 222 specifically provides that the probate petition can be filed only if there is a named executor in the will, otherwise not. And section 227 gives the effect, what will be the effect of grant of probate and letters of administration. The effect is that the person who has been granted a letters of administration or a probate will be entitled to administer the property as per the wishes of the person who has executed the will, wishes of the testator. And one more that will come when we go with the filing and procedure. But when after getting a letters of administration or a probate, although this provision is or this system is not followed in reality, in fact within every 6 months a person who gets a probate or a person who gets a letters of administration must report to the court who has granted it that how he has administered the property of the deceased, and he has to keep informed the grants this who gives this grant to him for acting on the behalf of the deceased. Then we go to the chapter 7, which is of a practice in granting and revocation. These are all section 217 onwards till 284 is the format of petition to be filed, that the letters of administration, how it has to be filed, that there must be either a probate or a letters of administration to be filed along with the original will, then along with the affidavit of 2 attesting witnesses which are named in the will. The attesting witness affidavit must give all the details, because the will has to be proved only by the attesting witnesses. No other person can prove the will. So attesting witness must give all the details in his affidavit, which has to be filed along with the petition itself, that he was present at the time of execution of the will. He has seen the executor putting his signature or mark at the end of the will. And he also has to say that he was present and he has also put his signature or his thumb impression on the said document at the same time along with the person who executes the will, and also along with the other witness who is going to be a witness in that will. If there are more than one witness. Then there are provisions regarding the caveats against the grant of a probate or letters of administration, which have been mentioned in section 284, that I will come subsequently regarding the caveat and the provisions thereon. Then under section 299 and 300, there is a provision for filing of an appeal which has been contemplated. In my note, there is a judgment of our division bench also, because there was an issue granting of a probate under section 300. It says that the appeal will lie to the only High Court. That issue has been reconciled by our division bench by seeing that if a letters of administration or a suit is decreed by the civil judge junior division accepting the will, then the appeal will go to the district court, as they have a concurrent jurisdiction. Although section 300 says that it is a jurisdiction of High Court, but district court appeal can be filed, and the citation is there in the note which I have already circulated. And then if a district court grants, then of course the appeal will lie to this honorable court. Then we go to more important part is proof of will, because ultimately we have to, after the death of the testator, the will needs to be proved. The will is the document which is to be proved only after the death of a person who executes it. This is the unique document, and therefore all these legal requirements are to be satisfied if a will is going to be accepted as a legal document, and a seal of a court is going to be put it on that. That's a legal declaration. All documents related to will ought to be in conformity with the law. Furthermore, the executor of a will should be legally competent. As I already said, that section 59 gives who is the person who is capable of executing the will. That is the minor, the person who is major, then a person who is in a sound mind and competent to contract. And then section 61 says that if a will is executed by fraud or coercion or undue influence, it becomes a void. And therefore all these requirements are to be looked in. And of course section 63, where the signature of a person who is executing a will, his witnesses at that time. There is no mandate that, although in a many of time we see that there is a mandate that doctor is attesting a will by saying that a person is in a sound disposing disposing mind at the time of execution, but that's not a mandate of law. But if it is there, it helps at the time of proving the will. Then we go to the basic legal proposition regarding the will, how it has to be done. Those are mentioned in section 278 to 79, the letters of administration, till section 285, where we come up to the stage of a caveat. The will is a document. Why there is the proof of will is why so important. Is will is the document which takes away the normal rule of succession. If will is not there in a picture, then the persons who are legally entitled to inherit the property are the persons who are going to get the property after the death of that person. But the will is the document which takes away those rights. Because a testator, if it is his own individual property, he can dispose it of by as per his own wishes, even to the stranger, even to the third party. It need not be only a family members. So while giving a grant, it is always advisable that more cautious is put while granting the letters of administration or a probate, because you are taking away the right of somebody who is otherwise legally entitled to claim the property after the death of the deceased. And one more reason is that because the person who has executed that document is no more to say that what disposition he has made. So therefore, yes, author is not there. Therefore, you have to go by the circumstances and the intention of the deceased. So that's the reason the law says that there has to be, you have to be very cautious while granting a letters of administration or even a probate, because it takes away the right of a succession in a family. So when we normally file a letters of administration with will or a petition for probate, if there is an executor, then first thing is required to be done is the citation is required to be served on all the persons who are legally entitled to claim into the property. So that in a normal rule of inheritance, if suppose a person dies, his legal heirs, that is his sons, daughters, or daughters or sons, or whoever are the persons who are entitled to, these are the persons required to be cited that the will is has been propounded by a person, by an executor or administrator, and therefore a petition has been filed. And once a petition is filed, a citation is required to be served on them. Once a citation is served on all legal heirs, then the legal heirs can take the steps whether either they can accept the will and then there is no problem on the contest. But if some legal heir feels that will needs to be contested and is not a genuine, there may be various reasons for not accepting the execution of the will. Either he may say that the person was not in a sound disposing of mind, he has been undue influence has been inserted by somebody, his physical or mental condition was not good, or some stages person may say that it is not even a signature of a testator. Those are the cases which can be taken up by a person who has been cited. So once a citation is served, the person who wants to object has to file his caveat and affidavit in support of a caveat. In affidavit in support of a caveat, the person who is filing the caveat must give all the objections which he has to the grant of a probate or grant of a letters of administration, because that affidavit is treated as his written statement in that sense. Because once a caveat is filed by any legal heir, then that proceeding are converted into a testamentary suit, and then it is to be tried as if it is a normal suit on a civil side, and all other provisions of civil procedure code are made applicable to the testamentary suits also. So the two things are required. One is there is one more possibility that a person, even before serving of a citation, can go and file a caveat to object a will if he is aware that somebody is going to do this. Then we turn to the main part, that is the proof. Before going to the proof, there is one more point which I want to urge is this: that property mentioned in the will can never be a subject matter of the testamentary suit. Once a petition is filed, a caveat is filed, somebody has objected to the grant, then it is converted into a testamentary suit. But earlier there used to be applications for injunctions or appointment of a court receiver in respect of the properties which are subject matter of the will. But that issue has been settled by our court single judge judgment of 2006, and which is confirmed in 2011. By saying that properties mentioned in the will cannot be a subject matter of a testamentary suit. The testamentary suit subject matter is only when whether a will is genuinely executed or not. And if anybody wants to have some interim relief in respect of the properties, that properties are being wasted, disposed of, or some third party rights are going to be created, then the option is kept open to such person to file an independent suit. And that is what has been held by Justice D.K. Deshmukh single judge judgment in case of Rupali Mehta, which is of 2006. That judgment also considers part 7, and that judgment also considers one aspect, that in case of an immediate arrest or a dispossession or forcible dispossession in respect of a property involved in the will, in such situation a limited relief can be granted by the testamentary court, but till the testamentary court can grant that relief till the person can go and approach the appropriate civil court for seeking those remedies. And that judgment is accepted by our division bench only. It's Justice Chandrachud and Justice Mohta's judgment in Vatsala Srinivasan. Those citations are mentioned already in that. One more aspect is in respect of this is considered is section 269 of Succession Act. 269, there is a provision for protection of the properties protection of the properties mentioned in the will. I'll just read that. When and how district judge to interfere for protection of the property. But there is a distinction made. Until the probate is granted of a will of a deceased person or administrator of his estate is constituted, the district judge within whose jurisdiction any part of the property of the deceased person is situated is authorized to and required to interfere for the protection of such property at the instance of any person claiming to be interested therein, and in all other cases where the judge considers that the property incurs any risk of loss or damages, and for that purpose if he thinks fit to appoint an officer to take steps. But the subsection 2 is important. This section shall not apply when the deceased is a Hindu, Mohammedan, Buddhist, Sikh or Jain. So although the protection is granted by section 269 that even the district judge or the court who is considering the application for probate or letters of administration can grant a protection, but that has been taken away in case of a Hindu or a Jains or other person. And that's the reason these two judgments make a reference that the property cannot be a subject matter of a testamentary proceeding. So the subject matter of a testamentary proceedings is only whether a will is properly executed or not, and whether a probate or letters of administration can be granted or not. So this takes us to the more important aspect is how to prove the will and what are the relevant sections and provisions are. So there are three important provisions. One is of course under the Succession Act section 59 and 63, which I have already pointed out. 59 is a person who is capable of making a will, he is competent to make a will, major of a sound mind and other things. The second is section 63, whether it has not been obtained by force, fraud or anything, and he has willingly executed the will. These are the two sections, and there are three more sections which are required to be looked into when we are looking at the proof of a will. One is section 67 of a Evidence Act. Evidence Act is a proof of signature and handwriting of a person alleged to have signed or written document produced. 67 is a normal section whereby any document is required to be proved in any civil or criminal court, where a person who has put his signature or who is aware about the handwriting can step into the witness box and prove that document. But that option is not available of section 67 because the person who has executed is no more and he has passed away. And therefore the section 68 comes into picture. It says that the proof of execution of document required by law to be attested. So such documents are where the attestation is compulsory. Then such documents needs to be proved under section 68 of the Evidence Act. Here in will, as we have seen earlier, that it has to be attested by two attesting witnesses. So the proof has to come from the attesting witness as contemplated under section 68 of the Evidence Act. And the only attesting witnesses are the person who can prove the will. The proof is, of course, the evidence is as we normally prove any other document. Here the person who has executed the document is no more there to prove his signature. Therefore, it is a duty of attesting witnesses that they must come or step into the witness box, establish that they were present at that particular time, they have seen the testator putting his signature on thumb mark, they have also put their own signature on that document, and they must identify, and all those things are required to be done. And there is one more provision, which is section 69 of Evidence Act, which says that the proof where no attesting witness is found. There are many situations where the attesting witnesses are no more. Either they are predeceased the testator or they are not available for. In such situation, it cannot be said that the will cannot be proved at all. Even if the attesting witnesses are not there, still will can be proved, but it has to be proved as per the normal procedure under provision under section 67 of the Evidence Act, that some person who was present at the time of execution, although he may not be a witness or he may not be named in the will, but he was present at the particular time, he can step into witness box and prove the will. There is two more type of persons who can do is that who can identify the signature of the attesting witnesses, because it is not sufficient that he must identify the signature of a deceased or a testator. The person who is going to prove the will under section 69, he has to identify the signature of the attesting witnesses by saying that I know this person for all these years, I know his signature, I have come across with his signature in normal working course and all that, and then he can prove that will. So it is not that first provision is that attesting witness should establish the truthfulness of a will. Even if attesting witness is not there, still somebody else who is present, who can identify the signatures, also can give the proof of a will. In this, there is one important judgment which is of 1958 of AR 1959 Supreme Court 443, which has been followed till now. That is, the last judgment is of 2021 of the Apex Court. I would just like to read two paras to give the clarity on this topic. I think the copies are not circulated, but I will read judgments. I think are not circulated. You can jot down para 18 to 24 and para 29 are the important paras, how the proof and how the bill has to be proved and all that. 18, para 18. No, it's Venkatachala Iyengar, 1959 Supreme Court. Para 18 gives the details about the sections which I have just now pointed out, that the section 67, 68, 69 as well as section 59 of a Succession Act and section 63. Both the parameters are required to be, even if suppose take an instance that witness identifies the signature, will is proved. But if a person who has executed a will is not competent to execute that document, still a probate or a letters of administration cannot be granted. So both the requirements are required to be simultaneously done at the same time. So that is what has been quoted in para 18, and para 19 I will read. However, there is one important feature which distinguishes will from the other documents. Unlike other documents, the will speaks from the death of the testator, and so when it is propounded or produced before the court, the testator who has already departed the world cannot say whether it is his will or not. And this aspect naturally introduces an element of solemnity in the decision of the question as to whether the document propounded is proved to be the last will and testament of the departed testator. Even so, in dealing with the proof of the will, the court will start on the same inquiry as in case of a proof of document. The propounder would be called upon to show by the satisfactory evidence that the will was signed by the testator, that the testator at the relevant time was in sound and disposing state of mind, that he has understood the nature and effect of the disposition and put his signature to the document of his own free will. Ordinarily, when the evidence adduced in support of the will is disinterested, satisfactory and sufficient to prove the sound and disposing state of the testator's mind and his signature as required by law, courts would be justified in making a finding in favor of a propounder. In other words, the onus on the propounder can be taken to be discharged on the proof of essential facts as indicated. So these are the parameters which has been laid down by the Apex Court in the year 1959, and the same parameters are followed till now in the recent judgment of Apex Court of a 3-judge bench in 2021 11 SCC 277 in case of Shri versus others. So the same parameters are there. Para 20 in the very same, because these line of the judgments are being followed till now since 1959. Para 20 speaks about the suspicious circumstances. I'll come to that little later, because that's one of the factor that all suspicious circumstances has to be explained by the person who is propounding the will. As we have seen in para 19, all other requirements, but in para 20, all suspicious circumstances need to be dispelled by a person who is propounding the will. And in para 21 of that judgment, one exception is carved out, that if a propounder is one of the suspicious circumstances mentioned, of course in the latter part I will give all suspicious circumstances, that if a propounder is getting more benefit than others is also one of the suspicious circumstances. So this is the manner in which the Apex Court has considered the proof of will, and both the conditions are required to be satisfied. One is of attesting witnesses' evidence as well as a state of mind and a physical and other capability of the testator. So that is what has been cleared in para 19 of the judgment, which is followed up till now in 2021 as well as in 2022. All the same line is being followed here. And then one more, as more elaborately, the suspicious circumstances are mentioned in a judgment which is of again Apex Court 2009 Supreme Court, page 687, that you will find those citation in the circulation. And in Apex Court, in the concluding para, Apex Court has given the suspicious circumstances, what can be termed as of course this is not an exhaustive list, this is just instances which has been given by the Apex Court. Suspicious circumstances can differ from case to case, facts to facts, because every fact will differ. Some of them have been specified in para 23 is the signature of a testator may very shaky and doubtful or not appear to be his usual signature, that one of the suspicious circumstances. Then the condition of the testator mind may be very feeble and deliberated at the relevant time. The disposition may be unnatural, improbable or unfair in the light of relevant circumstances like exclusion of or absence of adequate provisions for the natural heirs without there being any reason. So this is also considered as one of the, if entire property is given to a stranger, excluding all the legal heirs, then that is treated as one of a suspicious circumstance. And the apex court as well as our court says that the suspicious circumstances has to be dispelled only by the propounder, because he is the person who is coming and asking a stamp of a court on the will which has been executed by the deceased. So it is his responsibility to dispel all suspicious circumstances. Then one more has been mentioned is the disposition may not appear to be result of a testator and mind. So factually also the person who is alleging that the testator was not of his free will or mind has to depose that he has to give a firstly responsibility is on the propounder, because he has to establish that the testator has executed the document under a free will, there was no force, no coercion on him. If he proves, then the burden will shift on the person who is objecting to prove it otherwise. Then one more instance is given is propounder takes a prominent part in execution of the will. If he is the person who was present, who has insisted on execution of that document and he has taken all the part, because propounder will not take a part. For execution of a will, normally the testator and two witnesses are required to take part, but if a propounder has taken a part, then that is treated as one of a suspicious circumstance. Then the testator used to sign blank papers. If it has been proved that the testator was in habit of only signing the blank papers and leaving it, that is treated as one of the suspicious circumstances. Then the will did not see the light of the day for long, and then incorrect recital of essential facts. So these are all some of the examples which have been given by the apex court, which gives rise to a suspicious circumstance when the will is under challenge. So these are not this is not an exhaustive list. It differs from facts to facts, and a person can establish the suspicious circumstances depending upon the facts of the case. So this is in respect of a suspicious circumstance as noted by the apex court. And then we turn to one more topic, that is, as I have already said, that which has been reiterated in Rani Purnima Devi's judgment of Supreme Court, held that onus of proving the will is on the propounder, where however there are suspicious circumstances, the onus would be on the propounder to explain them to the satisfaction of the court. This judgment takes the case of 2009 little further. It says that only propounder has to dispel all the suspicious circumstances and satisfy the court. Then and I have already told that requirement of proof is section 68 of Evidence Act, required to be done by a testator by entering into witness box. Then one more aspect is this, that it's a normally we carry impression that if a will is registered means the will need not be proved in any other way. Registered will carries a more weightage and in the eyes of law in the court. But that also may not be correct, as held in 1962 Supreme Court. That judgment is also quoted. Mere registration of a will is not sufficient. There has to be, it says like this, there is no doubt that if a will has been registered, that it is circumstance which may have regard to the circumstances prove its genuineness, but the mere fact that the will is registered will not by itself be sufficient to dispel all suspicions regarding the execution. So merely because a will is registered doesn't mean that the court is going to accept and grant letters of administration or a probate. The apex court says that in spite of a will being registered, propounder needs, if there are suspicious circumstances as the case may be, are put by an objector in his caveat, then that needs to be explained by the propounder before getting the grant from the court. And then section 63, we have already seen that the attestation, in what manner attestation is to be done, that has been more elaborately explained in the case of 1998 Supreme Court Nagulpati, and that citation is also there in this. Then the one more situation which will come in, where both attesting witnesses are dead, as I have already pointed that out, and which has been taken care in the very recent judgment of 2020 Supreme Court 584, that citation is also mentioned. As it says that merely because both the attesting witnesses have expired doesn't mean that the will cannot be proved or no letters of administration or a probate cannot be granted. In such cases, a will has to be proved as if it is a normal document which is being proved in a civil court. Those parameters are there that the person has, I have already said that a person who has seen the testator signing, the person who has seen the witnesses signing at that particular time, at time of execution, or even a person who was acquainted with the signature of the deceased as well as the attesting witnesses also can step into the witness box and prove the will as required to be established under the normal document as under the Evidence Act. Then one more instance is there where Section 90 of the Evidence Act has been made an exception. Section 90 of the Evidence Act is where a document is more than 30 years. So in Apex Court judgment that is also quoted here, that merely because that exception is made in case of a will, merely because will is there of a 30-year-old and it has seen the light after 30 years doesn't mean that it has to be accepted under Section 90 as being a 30-year-old document and it can be straight away probate or other things can be granted. In respect of will, even if will is of a 30-year-old, still the normal parameters of proof as a signature of as an affidavit of or evidence of attesting witnesses, identification of the signature and other things are required to be done. Only because it is a 30-year-old document under Section 90 you cannot say that it is proved and therefore probate or letters of administration can be granted. And one more, since we are on a 30-year-old, I must point out that there is no period of limitation which is prescribed under the Act for filing of a probate petition or a letters of administration. The judgments are to the effect that you can file the letters of administration or proceedings of a probate at any time. There is no limitation which has been prescribed, and that's the reason this 30 years is relevant, because even after 30 years, it is not straight away taken as a document to be admitted under Section 90 of the Evidence Act. So here, after fulfilling all these requirements of proof and establishing the will and other things, then once a grant is given to a person, still there is one more provision which is contemplated in Section 263, which is called as a revocation or annulment for the just cause. It is not that once a grant is given by the court, it doesn't mean that the grant cannot be revoked. The powers are given under Section 263 itself, and the causes are also given when the grant can be revoked by the court themselves who has granted it. Those there are some examples or explanations which has been given. I'll just read out that. Revocation or annulment of just cause. For just cause, the grant of a probate or letters of administration may be revoked or annulled for just cause, and explanations are given. Just cause shall be deemed to exist. In fact, the just cause can be interpreted by the judge who is going to take a petition for revocation, looking into the facts and circumstances of each case. What can be the just cause cannot be a straight-jacket formula. It can vary from facts to fact. But under section itself, some of the instances are given. First is the proceedings to obtain the grant were defective in substance. If there are defective in substance can be of any type, such as non-service of citation to the legal heirs, or non-filing of a affidavit of attesting witnesses, or non-filing of a original will at the time of filing of this proceeding. It can be of anything, or if there are any other defects which has been found out, then in such cases the grant can be revoked. Then the grant was obtained by fraudulently by making false suggestions or by concealing from the court something material to the case. This is the another instance which has been provided, that if a grant is obtained by playing fraud on the court, in such situation, court has a power to cancel the grant. Then one more instance is given is grant was obtained by means of an untrue allegations of the facts essential in point of law to justify the grant. Those such allegations was made in ignorance or inadvertently. So if any untrue allegations are made on the basis of that a grant is obtained, still it can be revoked by the court. Then grant has become useless and inoperative through circumstances. There may be some circumstances which can be contemplated that the grant become useless or inoperative, or there can be various reasons that properties before getting this property is not there, or beneficiaries are not there, or any other circumstances are there. And then the person to whom the grant was made has willfully and without reasonable cause omitted to exhibit an inventory or account in accordance with the provisions of chapter 7 of this part, or has exhibited under that chapter an inventory or account which is untrue in the material respect. This is what I was saying, which is not normally done. That under chapter 7, once a grant is given, the person, either executor or the beneficiary, when there is no executor mentioned, he has to give an account of how he has administered the property or how he has administered the grant under the will. And that is one of the cause for revocation. If a person doesn't come back to the court and put it on record the manner in which he has administered the property of a deceased as per his wishes, then that can be given as one of the ground for revocation or cancellation. There are certain illustrations are also given. I'll just read it out. The court by which the grant was made has no jurisdiction. That it goes to the root of the cause. The grant was made without citing persons who ought to have been cited. That's all the legal heirs, as I have already said, that's a mandate. That all legal heirs are required to be cited because their rights are being taken away if the benefits are not given to them under the will. Then will of which probate was obtained by forged or revoked. If already it is by either obtained by forged or it is already revoked by some other court, and if a grant has been obtained again has been granted, then that is one of the cause. So these are all the illustrations which has been given under section 263, which says that the revocation is possible of a grant, but for that the various reasons which has been given under it. And this comes to the last this thing regarding appeal, because once a grant is granted, there is either revocation or there is a provision of appeal, which is there in section 299 as well as section 300 of the Succession Act. 299 is in respect of appeal from order of a district court. The 299, if proceedings are initiated before the district court, then appeal will come to the High Court. That has been contemplated in section 299. 300 is a concurrent jurisdiction of a High Court. The High Court shall have concurrent jurisdiction with the district court in exercise of all the powers hereby conferred upon the district judge. So earlier, the view was that against the grant, appeal can only lie to the High Court. And the district, since High Court has a concurrent jurisdiction along with the district court, but that has been taken care of in the judgment of our division bench of this group, which is citation is already there. That if it has been done by the civil judge junior division, or then the appeal will go to the district court, and if it has been done by the district court, then appeal will come to the High Court. But for and then there is one more provision is of a removal of executor or administration and provisions of succession. There can be an event that probate is granted or a letters of administration is granted, executor is appointed, and he is executing, while executing the grant, if he commits some misdeeds or if he commits some mischief, or he has not acted in consonance with the grant which has been granted, then section 311 is provided, where the courts can remove the administrator after giving a grant, and the courts have power to substitute some other person, competent person, as an administrator to administer the estate of the deceased. So this is how normally I have covered. I think I have covered all the. Thank you.
Thanks a lot, sir, for your insightful session and your valuable resources. I think the notes provided by you will be a boon for a young lawyers like us. I will now proceed with the questionnaire sessions. If there are some questions, you all are free to ask your questions.
Sorry? Of course it can be. As I have said, if an executor is named, then the probate can be filed. If there is no executor, then you can file a letters of administration. And that too only in the city of Mumbai. Outside, will is to be accepted as it is. If an objection is to be raised, then you have to go to the civil court. The only one that's what I have put it in a void bequest under section 112, 13 and 14. There is you cannot have a bequest by way of a perpetuity. So it has to be one bequest and that person becomes the absolute owner of that property after the demise and he can further bequeath it. Only one perpetuity is allowed, otherwise it becomes a void will. Execution can be done any place. The proceedings has to be initiated where the properties are situated. So even if say will is executed outside Maharashtra in respect of the properties which are in state of Maharashtra, then the court, civil court of the jurisdiction where those properties are situated can take up those proceedings. Outside India, the Indian courts will have to grant a probate. Although there is no specific provision, but if a person was a resident of India or a citizen of India is executed it over here, the will or probate can be granted, probate or the letters of administration can be granted by the court where he last resided or where he has demise, and then that can be operated over others.
The rights of the parties, the beneficiaries, if there is if the legal is a challenging the will be probated, then that would be if they are come to the newspaper and you said that public notice has been then they challenge. Then how does it automatically get converted into a testamentary?
After challenge it doesn't get. If a petition is filed, citation is served, a caveat is filed, and objection is raised, then it is converted into a suit. If a already granted will somebody has an objection, then section 263 which I just now pointed out is of a revocation. That if a citation is not served or I was not noticed or there is some fraud or a defect, that's what lastly I said section 263 where grant can be revoked.
Because any time a legal aid as and when it comes
Yes,
can always
yes.
come forward and his right is always protected and then
Subject to his proof, he has to establish that the objection to the will, and once a grant is done, then the parameters are restricted only in section 263. Although the just cause is mentioned, just cause can be anything. So, but you have to satisfy the court that there is a just cause or any other parameters mentioned under which a court can revoke the grant which has already been granted.
so grant of probate, grant of probate of probate would only mean that the will has been executed properly, but per se the rights between the parties would be by a civil suit.
No, if the rights will go to a person. If a will is probated, the rights under the will or probated will, the person will be entitled to claim that property. Then you cannot go to the civil court. During the pendency of that probate proceedings or letters of administration proceedings, if a protection is required to be applied for, then you have to go to the civil court, say for asking for injunction or appointment of a court receiver as we normally do under Order 39, Order 40 in respect of a normal civil suit.
So one last question, sir, in smaller towns, by neighbors or whatever, they move the district courts. They try to ask for probate. Then they realize that it is only in respect of say Bombay and Bombay properties you need to probate away. Then they regret the steps and then they go about putting away as if it is another document. So
legally it is not required outside the city of Mumbai to go and apply for proof of will or a probate or anything. Will has to be acted without any certification from the court. But if a person who wants to object to that has to go to the civil court and say that will for XYZ reason the will needs to be not to be acted upon. Status. Yes.
But some conditions like anything that I want, anybody wants, like yearly some thousand rupees.
That can be done but that is something which is a trust is created under a will or something where particular monthly income should go to some dependent on. That's a testator's wish. That can be provided for.
But can there be a bequeath like I'm giving this flat to my wife and after her demise it will go to.
No, that is the rule of perpetuity under section 114. It is
one person.
one person, yes, but you cannot say after her I will give it to him, after that person I will give it to other, or
But life interest.
yes, life interest can be.
After her death,
You cannot do it in perpetuity. That is what has been 114 says it's a void bequeath. Beneficiaries can apply, but they cannot apply for probate. They have to apply for letters of administration annexed with will. Sorry? Of course. Yes, he may have 10 properties, he may bequeath it to 5 different individuals. Need not be from family also, can be given to third persons if it is his own wish and will. Sorry? Yes, no bar on that. Yes? No, it's not. It doesn't become void. Then that part will go by way of a succession, or the person or the court who is going to see if there are more persons who has been bequeathed the properties under a will. Any one can go to the court for taking either letters of administration or establishing his right. Then, in such situation, court appoint administrator to administer the properties. Either one of the beneficiary can be appointed as administrator, or any other person can be appointed as administrator, and he will administer the property as per the wishes. But if one person or one bequeath person is not available, then that will go as per the law of succession, because the legal heirs of the person will be entitled to those properties. Mr. Bhadkamkar, not your personal problems. You can discuss with me. I know, that's why I am asking. Yes, that's good. Sorry, I didn't follow. Huh.
So therefore, this request cannot come into it. So with this land, because of residual instead of that,
Right.
residual legacy or other.
Residual legacy, if it is, it's good as a easy estate under the law of succession. If yes,
The person says, I will apply to XY. By the time that
XYZ or no more. Yes,
so this request cannot take effect.
right.
Now there are so many other properties.
So that's what I am saying. Then XYZ is not there. Then it will go by.
Become a residual legacy.
No, residual legacy. Residual legacy also must go to somebody. No,
Residual legacy is specific.
that is possible. It can go to, if it is mentioned in the will that rest whatever is not mentioned herein. But that may not be possible because that's only a residuary. Here the particular flat is mentioned to be given to XYZ. Then that may not be a residual. Residual is something which is not mentioned and which says that whatever remaining of my property which is discovered, right, then it goes by way of a succession. Then if property is not mentioned in the will, in specific, or say that rest of the properties, if it is found, discovered later on or whatever, rest of the properties will go to X. Then that is, if it is, that's what I said in answering him, that it will become, go by way of a succession as if there is no will in respect of that property. As if there is no will. Right.
This will be the last question.
Where one property is situated, you can file proceedings. Yes, registered will is not requirement, as I have already said. That registration has nothing to do with. Where one property is situated, where the testator last resided or died, that code you can apply for that. Thank you.
Thank you.
Thanks a lot, sir. I take a moment to introduce our dignitaries that are present over here. Madam Anjali Helekar, she is National Secretary for Akhil Bharatiya Adhivakta Parishad. Senior Advocate Sanjeev Gurwadkar, sir, President, he is President for Adhivakta Parishad Kokam Pran. Senior Advocate Abhay Khandeparkar, sir, he is President for Adhivakta Parishad Mumbai Unit. Advocate Shri Kulkarni, sir, he is President for Adhivakta Parishad Bombay High Court Unit. And Shri Kuldip Patil, sir, he is Secretary for Advocates Association of Western India. Yes. Now I kindly invite Julie. Yes. Anjali Helekar, madam. She is also Vice President of Advocates Association of Western India. I feel my apologies. I request Julie to kindly speak about Nyay Prava.
I'll just take 2 minutes. As our efforts to skill build for the young lawyers, Adhivakta Parishad has different initiatives like this lecture series. We also have quarterly bilingual publication of the Adhivakta Parishad, which is called as Nyaya Pravaha, and it is in Hindi and English language. The people like us, the young lawyers, advocates, can contribute articles to this, as well as we can subscribe to this publication. The publication fees are very minimal. For 5 years it is 1,000 rupees, for 10 years it is 2,000 rupees. So if anybody is interested, we would really like to know about that. And I think we will proceed with the vote of thanks now. Thank you.
Just a kind reminder, I think most of us have not got the notes. So if you all can kindly provide your email IDs and mobile numbers, we'll surely provide the soft copies to each and every one of you all. You all may kindly provide your contact number. I invite Shri Kulkarni sir to give vote of thanks.
I must tell you, all of you, that Mr. Damale was given an excellent lecture, and he was having very short time, because we opened on 3rd, and I think Anjali has spoken with him in the last week, and he has nicely covered the entire topic, and exactly within 45 minutes. I must. It's the quality of a senior advocate. And secondly, he is a senior advocate, therefore we always expect that senior advocate represent all the faculties, whichever advocates have any difficulty. Now all of us have know for sure that now he is an expert in the bill, so we can definitely have his assistance as and when occasion arises. I express my sincere thanks on behalf of Adhivakta Parishad to him, as well as the Trupti Loke, our one of the member Manda Loke, she is a younger sister. And with a short notice that we informed in the morning, and she accepted our invitation for this video recording. We express our gratitude as well as sincere thanks to Avi, to Mr. Kuldip Patil is here, and Anjali. In fact, this lecture is because of her. She has told me, no, Sriram, you have to ensure that the moment we reopen, we must go for this. And I express my sincere thanks on behalf of Adhivakta Parishad to all of you to make this function very nicely. Yes.
Now a new team also of Adhivakta Parishad is the field. So it's the teamwork that we are doing.
Yes, that's sir. In fact, that Rutvi, then Ame, then he is there, Akash. They have made this function in a short time very nicely. We could arrange it. And we hope and expect that next time also we will definitely trouble Mr. Damale on some other topic. Thank you all. Now we will have a national anthem. All of us will sing it together, and then the function will come to an end. Right? Bouquet राहिला. I will request. Yes.
विनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल वंग विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंग तव शुभ नामे जागे तव शुभ आशीष मागे गाए तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय
भारत माता की जय.